Podemos começar a transmissão, por favor.
Good morning, everyone who is with us via this live broadcast via the YouTube channel of the National Council of Justice. Welcome, everyone. This is a parallel event on the CPCJ on the subject decision-making and custody hearing in Brazil. This is a partnership between the CNJ, the United Nations Program for Development, and the UNODC within the program Doing Justice. This event is part of the Commission on Fight Against Crime of the United Nations, and we have this event being broadcast on English and Spanish, all via the YouTube channel of CNJ. Aiming at the objective of measures against biosecurity because of the COVID-19, all of the CPCJ events are being carried out 100% online with the use of video conference service. In order to start the event, we would like to invite for their opening remarks His Excellency Dr. Fernando Pessoa de Silveira Melo, who is an auxiliary judge of the Brazilian Council of Justice, working in the sector of inspection of the prison system. We thank you for your presence, Dr. Fernando. The floor is yours. Thank you very much. Thank you, Caroline. Good morning, ladies and gentlemen. And those of you who are with us on YouTube. I would like to start by mentioning how grateful I feel for starting this event here in this CCPCJ of United Nations on the issue decision-making on custody hearings in Brazil. First of all, I would like to greet Ms. Moema Freire, who is the coordinator of the Unit of Governance and Justice of UNDP Brazil, an organization that has supported us for all of this work that is being developed by the National Council of Justice in the execution of the program Doing Justice. Also, I would like to greet Mr. Nívio Nascimento, who is the coordinator of the state Rule of Law Unit for UNODC, an organization that supports this council in the strengthening of custody hearings in Brazil. It is an honor, ladies and gentlemen who are with us here, to talk to such a distinguished audience, such as the audience that we have here. In the last week, the committee has allowed for very rich debates organized by organizations, programs, and funds of the United Nations and member states with the goal of discussing the serious and contemporary issues related with criminal justice all over the globe. In our case, the diffusion of the activities of the Doing Justice program to other countries is part of the idea of publicizing internationally all of the efforts employed in the activities carried out by the National Council of Justice, and that we had the expectations that the interpretation into English and Spanish help us to reach the colleagues who are interested in the work that we develop here in Brazil. We've developed in Brazil in the last few years. The Doing Justice program is based on the partnership between the National Council of Justice and the United Nations Program for Development, UNDP, with the Minister of Justice and Public Justice through the executive branch, through the pain, with the objective of creating strategies to face these challenges that people face in the context of freedom deprivation, whether it's in educational or the penal system, aligned by a huge growth of the population deprived of freedom, which is also marked by the precarious situation of incarceration of this contingent, which has already been understood by our court, by our Supreme Court, as a state of things that is unconstitutional back in September of 2015. The actions of these programs are organized in 4 axes that are developed simultaneously. The strengthening and the qualification of the custody hearing are part of the first axis, as the incidence of entering the Brazilian criminal system. It is important to mention that the program counts on the contribution of the Office of the United Nations on Drugs and Crimes, UNODC, for actions aligned with this strand, such as the submission and organization of this present event. Doing justice bets on the qualification of the custody hearing as the entrance door to the criminal system. The fact of seeing and listening to the person right after their deprivation, the ceasing of their freedom is what ensures this method. Everything is done by the judge from his own office through the cold analysis of the registry, the records of imprisonment. Now, these hearings allow for the assessment of that deprivation of freedom happening within 24 hours after the detention of the subject that is under custody, acting more quickly for the determination of a better decision. It is true that the presence of the person arrested provides the judge better richness of material for the decision making, and this act also allows for network decisions, such as the construction of better effective fruits, both in the prevention against torture as well as in the social arena. In this sense, the support to Brazilian judges involved, for example, the elaboration of publication of 6 manuals that are part of what we call the collection and strengthening of custody hearing, allowing for the standardization, prevention against torture, social construction, the use of cuffs, and the manuals were created into summaries that were translated into English and Spanish, and they can also be read by our colleagues, judges from other countries. Undoubtedly, ladies and gentlemen, the 2 manuals about this decision making represent a relevant breakthrough in comparison with the efforts to contribute with the practice of judges who carry out these custody hearings. These magistrates have a gigantic responsibility because they are going to decide the best way through which that person will pay for their criminal action, whether it's by a release of the action or with the freedom or detention, provisional imprisonment. Today, in almost all of the states in Brazil, custody hearings are carried out not only for people who are caught in the act, it is important to highlight that, but also in the case of any prison sentence. This is why custody is a change of status of freedom of that person who is now under the responsibility of the state from that moment on, and that must be dealt with respect and insurance of their rights. The first manual is entitled The Manual on Decision Making in Custody Hearing, General Parameters, and supplies concepts about the essential aspects to be observed in the carrying out of the hearings, such as the insurances of the people who are deprived of freedom that must be observed. The third chapter of the manual received the title the decision process in custody hearing in 5 phases, and leads the reader to a thorough analysis of the hearing, the kind of decisions that are presented, as well as the elements that must be considered for that decision. This idea of parameterization of the decisions on arrests without condemnation does not mean that the judge is restricted or limited to their capacity of assessing individually the case. Much to the contrary, the decisional process in the manual, is important to highlight, aims at supporting magistrature about the consistency of their decisions, pointing to decisive elements that may influence both in the procedure as well as in the continuity of the process. The second manual is called Manual of Decision Making on Custody Hearing, Parameters for Crimes and Specific Profiles. It was built with the objective of providing elements that can improve this decision-making process, with a special attention to certain penal kinds that show up more frequently in arrests in the act. And we must pay attention to each case separately. This is why the document provides amazing subsidies, so that the judges can pay attention to the specificities that will show up in the hearing, going beyond the paper that is there, or the role that is there. So the document presents and debates issues related with vulnerable profiles such as women, indigenous, and people with disturbances associated with the use of drugs, with the goal of bringing techniques to assess the most challenging cases that may appear in every hearing. These two manuals can and must be used by our colleagues from the judiciary, but they're also geared towards every profession that acts in the different custody hearing schemes, providing a qualification that is dialectic and a better understanding of their functions and potentialities by all of the stakeholders involved in these procedures. For the current event, then, that had as the theme decision making, we've invited 5 judges or high court judges, one from every part of the country, to share their experiences on a local level about the implementation of custody hearing from our resolution from the 13th that was published in the year 2015. Ever since, the potential of hearings have been gaining momentum and improving their capacity of qualifying the entrance door to the Brazilian criminal justice system. The many articulations with the team of social protection, the so-called APEX, that today see these people before and after the hearing provides the judges essential elements to understand the vulnerability that is specific and allow for the referencing of people who receive, who are deprived of their freedom, and when released, they receive protection from the states and municipalities. Another action that increased the potentiality of the hearings as a moment to collect events. Local stakeholders are engaged in providing flows for all of these situations so that they respect the physical and moral integrity of the people who are under custody. That way, ladies and gentlemen, custody hearings are not just a moment, a legal moment, but also a moment for other articulations of the state and their public policies. They represent single opportunities that, at the same time, acting on provisional imprisonment, articulate social network, and fight against torture and mistreatment. In the specific arrangements, every state faced their own challenges, and today we are going to hear the words of authorities from the state of Acre, Santa Catarina, Rio de Janeiro, Ceará, Mato Grosso. in a video that was prepared exclusively to this occasion. I would like to thank each one of them who jointly with their teams have contributed in an essential fashion for today's debate. I am sure that this joint work developed by the people who are involved in the protection of the dignity of the people under custody and the implementation of legal procedures that are able to promote insurances is the way to the strengthening of custody hearing. Today's meeting is a clear demonstration of the actions from doing justice for the promotion of spaces and qualification of these hearings. This is why, ladies and gentlemen, once again, I would like to wish everybody a wonderful event. Thank you very much. Thank you for your considerations, Dr. Fernando, and now invite Ms. Moema Freire, who is the coordinator of the Unit of Governance and Justice for the Development of the United Nations Program for the Development. We also thank for your presence, Ms. Moema. The floor is yours. Thank you very much, Caroline. Good morning, ladies and gentlemen. I would like to start my talk thanking for the partnership and saluting CNJ through Mr. Fernando Melo and UNDC through Nívia Nascimento. Also, I would like to thank all of the courts in Brazil, especially those of which we are going to get experiences from that have worked jointly in this important agenda. Also, I would like to say that for the UNDP Brazil is a pleasure to follow up this event and keep these essential efforts for the qualification of hearings as the entrance door for the Brazilian justice system. This is why this moment is of great importance, because it is an opportunity to continue working in this strengthening of this important institute, as well as the promotion of a justice that is more and more focused on people, both in Brazil as well as in the region. I start my remarks setting some words regarding international relevance of the subject, especially in the context of the framework of the promotion of development. I would like to remind you that in the last two exercises of periodic review of Brazil that is carried out by the member states of the United Nations in the Council of Human Rights, great part of the recommendations that were received to our country have to do with the incarceration system. So in this perspective, we cannot enter this debate without following the strategies for the facing of excessive incarceration in Brazil, especially because this is a central issue in the advance of the agenda of human rights in Brazil, as well as an important topic for the progress of Brazil, such as the reaching of the goals that were accepted by Brazil and other countries in the 2030 agenda of the United Nations. And I would like to mention the quest for sustainable goal 16, which deals with the promotion of peace, justice, institutions. I would also like to highlight something that everybody knows, that in many countries that face economic challenges and political, incarceration becomes an instrument of intervention in the society, which ends up by exaggerating the selectiveness of the system, especially against those populations that are less favorable economically and socially, like the black population. I say that because of the continuous effort to improve the policies in line with the human development. We cannot move forward to higher levels of advancement without an approach on political policies that contemplate elements of humanization and inclusion, so that the responsabilization is not a synonym of deepening of structural problems of exclusion of the most vulnerable societies. We can't leave anyone lag behind. We can leave no one lagging behind. This is our goal, and this motto also applies to penal policies. And it is important to mention that the custody hearings at the entrance door to the system are important part of this process, because it brings this inclusion to all of the system. Now, talking about the doing justice program, such as Dr. Fernando said, this is an initiative of CNJ that counts on the participation of UNDP, and the program wants to face this reality of the system in Brazil as it is acts on the structural challenges that characterize deprivation of freedom. I would also like to say that the results that are being reached by the program that have been implemented since 2018 are being recognized in the country and internationally, especially because they reveal the good fruits that can be harvested from actions that focus on the increase of access to justice by the most vulnerable population. In addition to production of knowledge to qualify the carrying out of custody hearings in Brazil, and there are more than 25 products that have already been published on issues such as standards, social protection, prevention and fight against torture, among others. The program seeks to optimize flows and services, fostering on services to people under arrest, especially with the use of custody hearing and also live hearings after the COVID-19. I would like to take this opportunity to thank everybody who's with us to know the program. The program is available on the website of the National Council of Justice. Many of them have already been translated into English and Spanish, as Dr. Fernando has mentioned, which favors the dissemination and application on an international level, as well as a horizontal collaboration by Brazil to other countries. I'd like to remind you that the system allows for the people under custody capacity that their rights is ensured from the first moment, allows for a better trajectory of reintegration of these individuals to society. And it is important to mention the work of the network of reference and the reintegration of people to the society. That way we can get better results in social classification. I would like to thank all of the institutions and the people who are engaged in the fight against the current challenges since the entrance door to the end of the process of responsibilization and inclusion. I remind you that this is a ride of rights of inclusion and an effort to transform realities through which we can reach a society that is more and more pacific, fair, and inclusive. Thank you very much, and I wish everybody a wonderful event. Thank you, Ms. Moema, for your important remarks. We'd like to invite now His Excellency Dr. Nívio Nascimento, who is the coordinator of the unit State of Rule of Law from the UNODC. Would like to thank you for your presence. Dr. Nívio, the floor is yours. Good morning, everyone. It is a great honor to participate in this important event in the committee in the fight against in the Committee of Criminal Justice. I would like to start by greeting Dr. Fernando Melo, and by that way greeting all of our partners from the CNJ who are part of this partnership, who lead this partnership. I'd also like to greet my colleague Moema Freire, who I have worked with for a long time on this issue, and in these 3 years of the Doing Justice program, we are in the 4th year of implementation. And also, I would like to thank the work and the collaboration of the High Court judges that you are going to hear at the end of this panel, who have collaborated and show the power of this program that includes the participation of 25 courts of justice in Brazil. Well, we are here to talk about doing justice, and Dr. Fernando's remarks and Moema's remarks have already brought the general aspect, but I would like to talk a little bit more about what is this initiative of strengthening custody hearings. Interpretation apologizes, but Mr. Nívio is mute. Here it is. Now in the next slide, the component of custody hearings respond to the commitments that were assumed by the Brazilian government in the São José da Costa Rica Pact that was finalized in 1992. It contributes with Resolution 24 2015, 2013, and from 2015, that talks about people who are arrested need to be available to justice within 24 hours, and Law 11364 from 2019 that deals with the procedures for people in custody hearing. The commitment made by the UNODC, CNJ, and the UNDP, as well as the funds from the penitentiary system, seeks to strengthen custody hearing from four pillars. The first one, guidelines according to national and international rules, which is where the two manuals that have been mentioned on decision making are in. The network of studies and dissemination of good practices that seek to engage judges in these initiatives, as well as other stakeholders of the justice system. The local specialized consulting in 25 states of the federation. And the fourth pillar, monitoring, assessment, and advocacy. I'm going to mention some of these themes or of the points that have already been worked on. First of all, the contribution that Doing Justice has made with the collection and strengthening of custody hearings. There were 6 manuals that were elaborated by the UNODC team in partnership with Doing Justice and all of the courts participating. Today we're talking about manuals 1 and 2, but we have some more manuals that are under social protection, cuffs, and other instruments of contention and judicial architecture, as mentioned. All of these manuals, they have executive summary in English and Spanish, which allow for the circulation of this knowledge to other countries and other languages. As far as our actions in the States, I would like to mention some of the elements. First, the creation of the social protection system and expansion of the teams to support custody, people under custody, APEX, the national distribution of 233,000 graphic materials for people under custody and their families, which inform these people about their rights and what is a custody hearing. Our team, in partnership with CNJ and the procedures professionals from Doing Justice, have supported some important decisions by the CNJ, such as mental health, directed to indigenous people, street dwellers, people who need help, as well as LGBTQIQ plus community, as well as our catalogs that have been translated into 3 indigenous languages. And we had the launch in São Gabriel da Cachoeira, the most indigenous city in Brazil. The Doing Justice program, the National Council of Justice, has contributed to the translation into Portuguese of international material, many material from the UNODC, especially the online training on Mandela rules, but also many other materials that contribute to the advancement of justice, of this public justice in Brazil. Also, our fourth pillar, which refers to the production and analysis of data, focused and worked in partnership with our local consultants in the 25 OFs with units of the states of the country. And everything we studied, we transformed into knowledge to improve our action. I'd also like to highlight the fact that there is a platform on registry and analysis in the context of the COVID, in which custody hearings had to be suspended, and we had one single data center to have access to the data during the hearings. We had about 300,000 registries. This was an operation that was very robust, carried out by the UNODC, that had to be delivered in record time and contributed very strongly with the COVID response. Also, I'd like to highlight the data notebooks that were launched in different moments of the partnership. As far as self-study network and the sharing of good practices, I would like to highlight the High Studies, not self-study, High Studies Network with 16 national and international events disseminating the knowledge of these manuals. We had more than 1,000 participants, out of which 884 were judges, 846 were judges, which shows the engagement of the Brazilian judiciary with this initiative. And we also had the participation of judges from many states of Brazil, in addition to professionals who work in custody hearings and working with our manuals. And also, it is important to highlight the third forum of penal alternatives, FONAP, that was carried out in partnership with Doing Justice, CNJ, and UNDP. We had 3 days of international event, more than 1,000 people participating, 65 panelists, out of which 18 were international, and 20 products were launched. We had more than 5,500 views on YouTube. To continue in the area of sharing of good practices, the UNODC, in the context of this partnership, delivered a lot of up-to-date trainings for the Apex team, capacity building trainings for the filling out of forms to feed the data bank of the CSTAC, a training on update in custody hearing in Ceará. And in the context of this partnership, our team participates in events carried out by many state courts. This year alone, we had an event online in CND, which is the National Council, the Committee on Narcotics, and also an event in Maranhão on cuffs in English, in partnerships with Cuff Foundation. We have a QR code that allows for the follow-up of some of our publications with many free material that are available on the website of the Doing Justice program within the CNJ website. And now we also have a new agreement that was signed at the beginning of this year that has two main movements. The first one, work on this partnership to help in the process of interiorization of custody hearings in the interior of the country, bringing all of this knowledge that has been produced in these 4 years of partnership. And also, we promote the process of internationalization, which went through the CND. Now we are in the CCPCJ, and there are a bunch of other internationalization activities that are foreseen, seeking to expand and publicize the work, as well as learn all the practices from other countries. So the idea is an exchange and show what's been done in these years of partnership, but also seek to bring to Brazil some practices that may be adapted to the context of custody hearings. With that, I would like to say goodbye by finalizing my talk, and I would like to once again thank the UNDP, CNJ, DEPAIN, and Doing Justice program for the partnership, and wish everybody a wonderful event. Thank you. Thank you for your remarks, Dr. Nivio. It's a pleasure to see, in fact, the great volume of production, and which is the fruit of this partnership. And now we would like to ask the support to start playing the video that's been recorded with the testimonial of the 5 Brazilian High Court justices regarding the advancements and breakthrough on custody hearings in their own states.
No nosso estado do Acre, a primeira audiência de custódia foi realizada pela primeira vara criminal da comarca de Rio Branco, da capital, isso em maio de 2015. De lá para cá, de 2015 a dezembro de 2020, foram realizadas mais de 8.800 audiências de custódia em todo o nosso estado. Um grande impacto ocorreu no quantitativo de presos provisórios ou sem condenação dentro dos nossos estabelecimentos prisionais. A partir de julho de 2018, foi verificada a redução do número de presos sem condenação nos estabelecimentos prisionais. Isso revela o quê? Que na audiência de custódia se tem alcançado o fito de pensar a análise da decisão de conversão do flagrante em preventiva, tudo em observância à determinação constitucional do uso excepcional da segregação, da prisão, demonstrando o fortalecimento do Instituto como um mecanismo capaz de racionalizar a porta de entrada do sistema prisional. É possível destacar, a partir do apoio do CNJ, o seguinte: o desenvolvimento do programa Justiça Presente e atual Fazendo Justiça pela presença de consultores e consultoras no nosso Estado, no nosso Poder Judiciário, com atuação simultânea em todos os gargalos da execução penal. Também ações como a Central Integral de Alternativas Penais, o CIAP, na capital, e agora em vias de iniciar a interiorização no município de Cruzeiro do Sul. Ainda o Escritório Social, na capital, com recursos do DEPEN. E mais ainda, é importante destacar que a elaboração dos manuais e das formações realizadas são imprescindíveis para o alinhamento e atuação dos atores inseridos no contexto da audiência de custódia. Magistrados e magistradas, eles reconhecem seu papel de controle e não somente de chancela do conteúdo que vem nos autos de prisão em flagrante, maximizando com isso a audiência de custódia que fornece a presença da pessoa custodiada, garantindo a realização plena das etapas envolvidas na audiência de custódia. A política nacional adotada pelo CNJ em 2015, com a implantação das audiências de custódia, e em 2019, a partir do programa Justiça Presente para solucionar o quadro de crise do sistema prisional brasileiro de forma estruturada e sustentada, tem alcançado progressos significativos, notadamente no que toca à qualificação da decisão e à assistência à pessoa apresentada a partir de encaminhamentos sociais. A partir da análise dos dados das audiências de custódia do ano de 2019, mostrou-se quanto às vulnerabilidades das pessoas apresentadas à justiça criminal e traz à tona o filtro social e as causas subjacentes à prática de diversos delitos. Os dados revelam uma convergência entre os bairros de origem dos apresentados em custódia e os bairros que também apresentam piores indicadores socioeconômicos, o que sinaliza para todos nós uma necessidade de abordagem multifatorial com foco em intervenções sociais comunitárias nestes bairros.
A unidade de audiências de custódia da comarca de Fortaleza foi instalada no dia 21 de agosto de 2015, quando houve a primeira sessão durante solenidade na sede do Tribunal de Justiça do Ceará. A nossa instituição foi uma das primeiras a implantar uma unidade exclusiva e privativa para cuidar de audiências de custódia no Brasil, projeto de iniciativa do Conselho Nacional de Justiça. O Conselho Nacional de Justiça colabora com o fortalecimento das audiências de custódia por meio de projetos e parcerias, resultando em ações que permitem desenvolvimento de políticas públicas e o aperfeiçoamento das audiências realizadas no nosso Estado. Recentemente, em parceria com o Conselho Nacional de Justiça, o nosso Tribunal Alencarino ofertou curso de atualização em audiência de custódia, no qual as juízas e os juízes que atuam nessa área foram capacitados. Os laudos periciais de exame, a maioria contendo fotografias, viabilizam, em regra, a identificação pelos magistrados de eventuais lesões sofridas pelos custodiados no momento do ato prisional. E associado às demais informações colhidas na audiência de custódia, caso seja verificado qualquer indício de tortura ou maus-tratos, auxiliam na determinação de imediato do encaminhamento de ofícios aos órgãos responsáveis, a fim de que tomem conhecimento e adotem as providências adequadas.
A implantação da audiência de custódia no estado de Mato Grosso deu-se em 2015, por recomendação da Resolução 213/2015 do Conselho Nacional de Justiça, que, por sua vez, atendia às orientações do Pacto de São José da Costa Rica e do Pacto dos Direitos Civis e Políticos de Nova York. Verdade é que a resolução antecedeu, inclusive, a legalização da audiência de custódia implantada apenas no pacote anticrime no ano de 2019. Antes da audiência de custódia, nós tínhamos aproximadamente 60% de prisões decretadas no curso do processo. Desde a implantação do núcleo, no estado de Mato Grosso, pelo menos na comarca de Cuiabá, este número reduziu para 42%, ou seja, 57% das pessoas presas em flagrante delito são hoje colocadas em liberdade. E este número tende a cair. Esperamos que dentro de pouco tempo esse número possa chegar no máximo a 30%. Isso porque nós devemos trabalhar com a consciência de que vigora na nossa Constituição Federal a presunção de inocência. O réu precisa ser tratado como inocente no curso do processo. Ele só perde esta condição de inocente após o trânsito em julgado da sentença condenatória. A audiência de custódia foi implantada inicialmente apenas na capital mato-grossense, mas hoje todas as comarcas do estado de Mato Grosso se realizam audiências de custódia. E a nossa intenção do GMF é levar toda a estruturação necessária para que as audiências de custódia no interior possam funcionar nos moldes da capital mato-grossense. Inclusive, na audiência de custódia, o juiz é orientado, se ele necessitar, de informações fornecidas por assistentes sociais e psicólogos. Decidindo o juiz por colocar a pessoa em liberdade, essa pessoa será acompanhada por uma equipe multidisciplinar, composta de psicólogos e assistentes sociais, para que possam, em sendo o caso de vulnerabilidades, inseri-las na rede de assistência da União, do Estado e do município. A audiência de custódia não se mostra importante tão somente para colocar o preso diante do juiz e ele analisar se aquela pessoa presa em flagrante deva ser colocada em liberdade ou não. Em muitas situações, há relatos de tortura que o juiz precisa verificar. Daí porque nós temos na audiência de custódia da comarca de Cuiabá, nós temos uma equipe de médicos legistas que fazem o exame de corpo de delito e já apresenta aquele exame naquela audiência de custódia ao juiz. Se houver evidências de que aquele preso foi torturado, já se faz os encaminhamentos para os órgãos públicos para perseguir a responsabilidade desses torturadores.
São as audiências de custódia. Nós, desde 2015, começamos aqui no Rio de Janeiro, após a edição da resolução do CNJ, do número 213, nós passamos vamos testar como se realizar uma audiência de custódia. E, inicialmente, ela se realizava aqui no Fórum da capital e somente abrangia os presos que foram detidos por fatos praticados na capital. Designamos um grupo de juízes que ficaram responsáveis pela audiência de custódia e, pouco a pouco, mais especificamente em 2017, quando ainda não estávamos na segunda vice-presidência, mas éramos supervisores do GMF, nós ampliamos a audiência de custódia para abarcar também as prisões que ocorriam na região metropolitana. O TJ realizou uma série de obras e vamos usar como ponto inicial a audiência de custódia de Benfica. Nós realizamos diversas obras que possibilitaram uma logística que estava de acordo com as recomendações do CNJ. Benfica hoje é responsável por 85% das audiências de custódia, tem uma equipe de juízes lá, são 9 juízes, sob a supervisão de uma juíza titular de uma vara criminal, e Volta Redonda e Campos, cada uma delas tem apenas um juiz. Foram realizadas diversas reuniões entre os juízes, no sentido de que as decisões tivessem uma padronização, mas sempre respeitando o entendimento e a liberdade de cada julgador. As audiências elas se realizam de segunda a segunda. todos os dias da semana, inclusive feriados, dia 25, dia de Natal, 1º de janeiro, primeiro dia do ano, é ininterrupta. Nós, durante a pandemia, realizamos todas essas audiências de forma presencial. Apenas durante 2 meses, na crise maior da pandemia, junho, julho e agosto de 2020, é que nós não realizamos a audiência presencial, até porque havia uma limitação da própria movimentação das pessoas na cidade. Mas a partir de agosto de 2020 até abril de 2022, o tribunal sempre adotou medidas de segurança, controle de acesso, medição de temperatura, proibição de acesso de pessoas, atores do processo, como juiz, defensor, promotor, o próprio preso sem as máscaras, com higienização total, diária dos ambientes de trabalho, disponibilização de álcool gel. Todas essas providências foram adotadas pelo Tribunal de Justiça na busca da realização da audiência de forma presencial, porque entendemos que a audiência de custódia tem que ser realizada presencialmente ou preferencialmente, só em casos excepcionalíssimos é que se justificaria uma audiência por videoconferência.
As audiências de custódia regulamentadas por uma resolução número 1, de 20 de abril de 2016, que, para adaptar e adequar-se ao que o Conselho Nacional de Justiça havia proposto, determinou, então, que o procedimento fosse realizado em 14 comarcas do Estado. A partir da resolução número 8, de 10 de setembro de 2018, nós passamos, então, a expandir para as 111 comarcas do Estado, e no Estado isso foi feito através da regionalização em 37 comarcas sede. É importante registrar que nesse formato que nós estamos usando aqui no Estado de Santa Catarina, das videoaudiências, das audiências por videoconferência, ela se dá tanto nas prisões por prisão em flagrante, quanto por todos os tipos de prisão. Prisão por mandado, também por alimentos, também por prisões de crimes afiançáveis. Então, nós temos realmente 100% de eficácia nas nossas audiências de custódia.
Eu registro especial agradecimento.
I would like to thank all of the High Court judges who have supported us, collaborated in this event, and I would like to pass the floor to Mr. Mello so he can do the closure. Thank you very much, Caroline, and once again, ladies and gentlemen, after these amazing talks by those that came before us, live, Dr. Moema and Dr. Nivio, we were able to follow video that is very good in the sense of bringing clarity. In the video portrayed 5 High Court judges from 5 different regions of our country. So with that, I would like to close this event by reinforcing and registering that all of the manuals that are published by the National Council of Justice through the Doing Justice program are available on the website of publications of the program on the website of the National Council of Justice. And for that reason, I would like to invite everyone to navigate through these materials, especially those that have already been translated into English and Spanish. With these considerations, I would like to thank everybody who was present here and also those who were with us on the YouTube channels. And with that, I close the event and I wish everybody a wonderful Friday to everybody. Thank you. And I wish you a wonderful day.